Ms. Haig is going to go first, is that right?
Yes.
Thank you. Before you start, we're going to begin with the application made by the appellant that you shouldn't be allowed to raise a challenge to the finding of fact made by the committee.
Yes.
And we've obviously read both that application and your response to it. But we thought it only fair to give you a chance to augment your response orally rather than deal with the matter purely on the papers. And that's the purpose of the first stage this morning. It may not take you half an hour, but
I don't think it
please add anything you want to add orally. Just so you understand, the concern which we have is not the procedural concern that you should have done it by notice of application to amend your notice of objection. That may or may not be right, but that's not our concern. Our concern is quite simply that you're seeking to raise, as far as we can see for the first time before the board, a point, namely an Edwards and Bairstow challenge to findings of fact by the committee, which was not only not raised before the Court of Appeal, but which your side declined to raise when asked by not the Court of Appeal, the Supreme Court, when asked by the Supreme Court whether you were raising it or not.
Yes.
So it's the concern which we have is dealing for the first time with an important point that the local appellate court, in this case the Supreme Court, was not invited, indeed was invited not to deal with.
Yes, we understand that.
Right.
Would my lord prefer appearances first, or shall I just deal with the...
Well, I think we can take that.
Thank you.
Ms. Haig.
Thank you. We acknowledge the very peculiar circumstances of this appeal. It is a case where the respondents were successful on both occasions before the lower courts and for different reasons. And those reasons were different from what was contended by the respondents before the lower instances. We have accepted in our written case that there are flaws with certain aspects of the reasoning of the Supreme Court as well as that of the ARC. And this is why we decided to approach this appeal with the intellectual honesty that it deserves by seeking to go to the root of what was at the core of the appeal, which is whether an intention existed in 1988 to do a morecellement.
Am I right to understand from your written case that this is now the only basis on which you're contesting the appeal?
I understand that the board has also asked us whether there's any other issue that we would like to raise, and should the board not hear us on the point of law, we will then try to build on the alternative argument which Mr. Tim, the counsel for the respondent before the Supreme Court, tried to argue, which is even if an intention existed to do a morecellement in 1998, it does not automatically equate to the land being acquired in the course of a business of buying and selling. In other words, that the land did not constitute trading stock on acquisition, even if there's an intention to do a morecellement at the beginning. And this is an argument that he then pivoted to when he did not raise the point of law.
So is that your badges of trade argument?
No, the badges of trade argument is our Edwards and Bairstow point.
Okay.
Yes. So it was certainly not our intention to try to introduce a new point through the back door, but really trying to narrow down the issues on this appeal. We accept that despite trying to raise the question of finding of fact on no less than 3 occasions before the Supreme Court, when invited to do so by the Supreme Court, the then counsel for the respondent did not argue a point of law. That was unfortunate, for want of a better word. But we say that in this case, there are exceptional circumstances that would warrant the board permitting the respondents to argue the point, and that it would be a plain injustice, in this case, to refuse leave. And we say so for essentially 3 reasons. The first reason is that whilst the error of law point is a new one, the finding to which it relates formed the basis of the dispute between the parties from the very beginning. It goes to the heart of the appeal. It is the basis of the assessment of the appellant that an intention to do a morecellement existed in 1988. The respondents are not asking the board to consider any new evidence. We accept all...
This is your second reason.
No, that's still in
It's
my
still part of the first one.
part of the
Right,
first
okay.
reason. It's a subsection to the first reasons. We are not asking the board to consider any new evidence. All the primary facts are undisputed. In the case of Blue Lagoon, I believe that the appellant referred to that case in its application for objection. I believe the board declined to consider the point as it could have raised new facts, new evidence. This is not the case here. We do not seek to rely on any new evidence. We are simply asking the board to consider whether, based on the undisputed primary facts on record, the ARC was reached a reasonable conclusion within the meaning of Edwards and Burstone.
I thought the facts were disputed in the ARC. That was the whole point. Your
No,
grounds for cross-examine.
the primary facts, as opposed to, I know there's a slight nuance sometimes between an inference of fact and the primary facts. What I mean to say is that the primary facts are not disputed, but the inference from which that the ARC drew from the facts are. We also say that there are, and that is still part of the first reason, we also say that there are, there's a unique feature to this particular case, which again would mean that it would be a plain injustice to allow an error of law to remain uncorrected. As the board may be aware, there was an earlier case heard this year before the board. Lord Leggett and Lady Rose were before this case. The case of Dominique Galea and Revenue Authority, Mauritius Revenue Authority, in which the board found that the ARC made a material error of law in the definition of the term with a view to profit. So in the definition of the term profit-seeking intention, in the definition of business. And whilst we are not asking the board to automatically assume that an error of law has been made here, we do realize that we will have to convince the board of that. We say that in this case, if a similar error was made in the same ruling, it was the same ruling of the ARC, in relation to the same term.
It's not a similar error, though, is it? Because the error in the earlier case was treating the test of whether there was an intention to make a profit as an objective test rather than a subjective one.
Yes.
I assume you accept that it's a subjective test here, and it's plain that at least it seems plain from my reading of their decision, that the board treated it as a subjective test of the intention of the participants who comprise this society.
Yes, the board found in the earlier case that the material error of law was the ARC adopted an objective test, and we agreed it is not as straightforward here because we are arguing an Edward and Bernstow error of law. But if the board permits us, when we go through the reasoning, we will explain that the question of what a reasonable man would have done and ought to have done played heavily in the ARC's reasoning.
I think also, as I recall last time, it was common ground between the parties that the test ought to be subjective.
Yes, it was common ground between the parties last time. I hope it is also common ground this time that we're looking at the subjective intention.
But that's your second point, as I understand it.
I'm still on the first point,
you're still
but
on the first,
I'm
okay.
nearly done. This was my first point.
One C, you might call it.
This was my first point, that it would be an injustice if a similar error, not the same error, a similar error was made in the same ruling in relation to effectively the same term, business.
Okay.
So the second point is that we say that in this case, the question of intention or purpose played no part in the Supreme Court's reasoning. Its rationale in finding that Section 10(3)(c) of the Income Tax Act was not applicable is simply that bare land was converted and was transformed. In fact, the appellant in its written case says that the proper characterization of whether an item falls under 10.3c is the taxpayer's purpose and the business character of the land, and that the Supreme Court did not do so. We say that
they not do so because it had been decided by the ARC, not challenged.
it played no part in the decision, in the rationale of the ARC, of the Supreme Court, apologies. The Supreme Court does not take into account at all what would or could have been the intention. They say that it is simply because bare land is transformed, then automatically you fall out of section 10.3c, regardless of, well, they do not actually comment in their rationale on the intention. And it is not a concurrent finding of fact. Simply referring to a fact doesn't mean that they affirm it. And we also the appellant referred to the case of Didier and Roy in its...
Yes, I mean, I hope I made it clear that we're not here, our concern is not a Didier and Roy concern in a strict sense. Sure. It's a concern that we're being asked to deal with an important point without the benefit of it having been put forward to or dealt with by the appellate court in the country in question here in Mauritius, from which the appeal comes.
Yes, and we understand that.
Obviously, it's related to Didier and Roy, but it's not, strictly speaking, a pure Didier and Roy.
Yes.
Well, there's an exception indeed in Devian Roy,
yes.
and therefore they didn't put it that way because the case hadn't been decided, but for Edwards and Bairstow type of argument.
Yes, it is an exception, and also we say that in Devian Roy it says that a finding of fact is either found in the court order itself or in the judgment, but it must be directly related to the decision. And in this case, it was not related to the decision. The decision is purely, it is not bare land anymore. So the question of, and we certainly wouldn't speculate as to what the Supreme Court would have said had an Edwards and Bairstow point been argued.
But if you had raised it and they had dismissed the Edwards and Bairstow point, then it would have been a concurrent finding of fact within Devian Roy.
Yes.
Yeah. So the question is whether by not raising it in the Supreme Court and seeking it only to raise it with the board, you can rely on the fact that there's no concurrent finding of fact when there might well have been if you had raised it before.
Even if there was a concurrent finding of fact, we say that it would fall within one of the exceptions stated by the board in Devian Roy, which is that I believe the wording is that if there's no evidence to support that finding, then that would be an exception from the settled practice.
But is that your case? No evidence?
No, our case is that no reasonable tribunal would have found. But we rely on, I can't recall whether it was Lord Radcliffe or Viscount Simmons that said that whether it is said that there's no evidence or whether there was a misdirection or whether no reasonable tribunal, all three propound the same test. It's really that you could not simply have come to that conclusion.
They turn what would otherwise be a question of fact into a question that's treated as one of law.
Yes, indeed.
So that's your second point.
That's my second point, and my third point, I understand your lordship indicates that your concern is not procedural. We would have simply said that the respondent could not have cross-appealed in any event, but we do accept that the point of law wasn't argued before the Supreme Court. We simply wanted to raise that
Sorry,
point.
could you say that again?
That the respondent could not have cross-appealed
Yes.
before the ARC or before after the judgment of the Supreme
But
Court.
you could have put in a respondent's notice seeking to uphold on alternative grounds.
Before the Supreme Court.
Is there a procedure in
No, there
Mauritius
isn't.
for respondent's
There
notice?
isn't.
I thought the point taken against you was that you could have asked the ARC to state a different...
The better case, yes. And our answer to that, and this is why I wanted to raise this point, that is plainly wrong. When we look at the ARC rules, the asking to state a better case is purely to reflect, for example, if there was a primary fact that was wrong, plainly wrong. So, for example, if the case said the land was bought in 94 as opposed to 98, that could be used. But the case stated, Rule 4 of the ARC Rules 2007 says quite clearly that the case stated has to contain the decision of the ARC. It is not an opportunity for the respondent to ask the ARC to revisit a finding of fact. So it would not have been open to the respondents to ask for better case stated, to ask the ARC to revisit that finding.
But whether or not there's a procedure for respondent's notice, it must be open to a party in the Supreme Court to say that I wish to argue that the decision being challenged was right, but for a different reason from the one that they gave.
Yes.
And that is the case I want to make before you.
Yes, and that is what we say that the counsel for the respondent tried to do.
Well, he might have set out with that intention, but he didn't fulfill it.
Yes, we accept that he did not argue an error of law when he had the opportunity to do so. All we are trying to explain to the board is that, notwithstanding that, in this case, there are exceptional circumstances.
Right. Good. So those are the three reasons.
These were my three reasons, and I think I also mentioned the alternative ground if you're...
Yes, and the alternative, as I understand it, is saying land isn't, or isn't in this case, trading stock.
Trading stock. So it's to build on an argument which the then council did raise as an alternative argument before the Supreme Court, and it also is also consistent with the appellant's case, which is that the Supreme Court had to consider two aspects, which is the taxpayer's purpose and the business character of the asset, and we will be building on the second aspect, which is the business character, not being trading stock on acquisition.
And that's all you want to add already?
Yes.
Thank you very much. It was very concise.
Thank you.
The board will briefly retire to consider what it should do about the appellant's application, and will continue. Be good enough to wait. We'll be back shortly. Well, Ms. Hay, Mr. Baker, we're grateful to both sides for their written submissions and Ms. Hay's oral submissions on this objection. We've considered it, and we have decided that we should accede to the objection. In other words, we have decided that it's not open to the respondent to now seek to challenge, even on Edwards and Bairstow grounds, the findings of fact of the committee, the ARC, and that your response to the appeal must be confined to other matters. We will give reasons for that in due course in our advice in our judgment. But we won't take up time doing that now. We've also considered the proposed timetable. Our view is that, having regard to the way you have expressed the outstanding point, which is that whether the land could be trading stock, we'd like to hear your side on that first. It'll help get us a better focus on that point than we have so far. I think it will probably also help Mr. Baker, and I don't think it will cause you any disadvantage to have the first and the last shot on it.
Thank you, my lord.
Mr. Baker, are you content with taking that course?
Very content indeed. I was rather wondering what I was going to say.
Well,
but may I just make a small point, and that is this trading stock point is also a new issue that has not been raised previously. taken that.
we have an uncertainty in our mind about how squarely this has been raised in the
Yes.
current application, but we hope that we will get a better grip on it when we've heard Ms. Haig explain it all.
But I entirely agree with you, yes.
Right, Ms. Haig. And now that upsets the timetable here, but I'm sure, judging by the concise way in which you made your oral submissions thus far, we can let you get on with it without having to impose anything too strict in terms of it.
That's fine. Thank you, my lord. So perhaps I shall first take you to the part of the proceedings before the Supreme Court, whereby Mr. Utim raises the argument as an alternative argument. And if I can take the board to page 141 of the EB.
The numbers on our electronic screen correspond to the ones in the bottom right-hand
Yes,
corner.
bottom
Is
right.
that right? Yes.
Exactly, not the
Not
one
the
in
ones in the
bold
middle.
in the centre. Exactly.
No, I have to say we did, I think, have some difficulty.
Yes,
finding
we
the
did
page,
too.
The helpful page numbering in your original case
Yeah.
with the bundle in its current form, but I think we can
Yes,
struggle along as long as you give us the page numbers.
Yes, so bottom right, 140. So 141, apologies. So this is where their lordships are quizzing the then counsel about what he has to say about the fact that there was a finding of fact of the intention from beginning. And at the bottom of the page, Mr. Utim says, because it would amount to capital gains, it's only when I develop it. Now, the situation would be different if, I am a property developing company which buys and sells as a business, buys and sells immovable property, but we are not in this type of situation. So, in a sense, his argument is, regardless of an intention to do a morecellement in the future, which existed in 1998, that does not automatically equate to the land being bought in the context of a land dealing business. And I know that Section 10.3c does not actually say the word land dealing. It is a term that was used by their lordships in the de Morecellement case, in which they found that subsection was not applicable because it was not a land dealing business.
So is your point that this was a sort of a one-off thing rather than lots of occasions on which they bought and sold land? Or I still don't quite have the point in my mind.
Yes, my lady, it is not our point. We accept that case law is very clear that an isolated transaction can constitute a trade. Our point is simply regarding the timing for which the land was held. That is not indicative of
You say timing?
the duration for which the land was held, not indicative of a trading stock, and we will be making our submissions based on that.
Yes, I mean, Mr. Atim's observation here is a rather negative one. Well, we're not in that type of situation. Yep. I think I'm looking to see
what the point is
about the situation which we are in and why it's different from that contemplated by the relevant provision of the Act.
Yes, and we will build on that. We were simply trying to show that this is not a new argument. So, first of all, I would like to start with the finding with the judgment of the Supreme Court in finding that 10.3c was not applicable, and that is at page 155 of the EB. So, in finding that, so essentially the Supreme Court finds that 10.3c is not applicable and therefore displaces the finding of the ARC that the land has been bought in the course of a business and buying and selling property.
This is the bare land point.
The bare land point, exactly. So the Supreme Court finds in the second paragraph, at the last two sentences, We therefore find there was in fact a change in the purpose and nature of the land, and in any case, the circumstances show that the respondents were in fact engaged in an undertaking or scheme entered into for the purpose of making a profit. So we say that this reasoning holds if the land has been acquired with a view to resale at a profit, but does not form part of that person's trading stock on acquisition. So it's really the point about, we raised the Supreme Court's reasoning to explain that the finding of
say if this holds true, if the land is acquired with a view to, what was it you said?
Making a profit.
to make a profit in the future, but did not form part of the trading stock of the person on acquisition, that means that 10.3c is not applicable.
But why does it not form part of, what stops it from being part of the trading stock?
This is where we will get to next.
Okay.
We will try to explain to the board why we think that that it is not trading stock. So I will now take the...
Can I just say that the problem that's going through my mind is if you set up a business with a view to buying and selling widgets, then you buy a widget, on the face of it, the widget is trading stock of that business.
Yes.
Because it is buying the very thing which you are forming your business to buy and sell.
Yes.
Now, why is land different?
Land is not different, and we say that the decisive factor is the duration for which the land is held. And again, we will certainly not...
So you say even, it doesn't matter that there was the finding that at the time they bought it, their intention was to sell it for a profit. Because they held it for so long before developing and selling it, that prevents it from being trading stock.
Yes, and we will give 3 reasons for that, and I will get to that, my lady. But I wanted to take the board through the reasoning, the finding of fact, and the question which the ARC answered first, because this will explain why we say there is a gap between the finding of fact of the ARC, that there was an intention to do a morecellement in the future, and the conclusion that therefore 10.3c applies.
And as I understand it, this is a pure argument of law.
Pure argument of law.
Yes.
Pure argument of law.
And it doesn't depend on it being land rather than widgets.
No. So if I could take the board to page 40.
So we're now in the ARC's.
ARC case stated on page 40, first paragraph. So the ARC says, and this is a question that the ARC addressed its mind to. And the ARC said, regarding the first issue, and the first issue was whether the society was involved in a business of buying and selling land, the committee will quote the case of d'Anjou to the effect that the question to be asked is whether the purchase was made for no other purpose except that of resale at a profit. And if I can now take the board to page 42, after going through, in the penultimate paragraph, after going through all the badges of trade, the ARC says, in these circumstances, the committee has no hesitation in holding that the facts of this case show that the applicants from the very beginning bought the land through the Société du Vieux Moulin with the intention of having a morecellement done after a few years in view of making a considerable profit. And I'll pause there. So there's a question to be asked has the land been bought for no other purpose than resale at a profit? The conclusion is that they had an intention from the beginning. But 10.3c does not actually say that land has been sold when it was acquired for no other purpose other than resale at a profit. 10.3c says that the land was acquired in the course of a business of buying and selling property. And we have 3 points to make on that. The first is, I have to be candid, your lordships and your ladyships, we have found no judicial authority in Mauritius or New Zealand, for that matter, on that. So we have tried to interpret 10.3c as best as we can. And 10.3c refers to the term in the course of. And we say that that term is to be read as during or at the same time. In other words, at the time you are buying the land, there is a business that is either already existing or the business is established when you buy the land. It is not disputed here that the land was left idle for at least 11 years. The EIA license was obtained in 1999, 11 years later. We say that it would not reflect economic reality, to use some of the words used by the board in Demahusem, that a trading stock is left to lay idle for such a long period of time.
Let's say it was a very much shorter period. It was a month.
Yes.
What do you then say?
That if it was a month, then we would agree that the ARC might have well been entitled to find that there was trading stock
Why?
on acquisition, because it is indicative of a business of buying and selling land.
But you've accepted that you can have a trade that deals with only one.
Yes, yes,
Position
and
of
that is
sale.
why we're not relying on the fact that it was an isolated transaction.
Well, why does the fact it takes a long time before you do or are able to sell it make any difference to whether it was in the course of a business when you bought it? I mean, if the ultimate intention is to sell it, why does simply the fact it takes you a long time to realise that intention enter into it?
Because we say that the business hadn't, there's a nuance, a very subtle nuance to be drawn between buying an asset with the intention of embarking into a project with it in the future for resale at a profit, and buying an asset in the course of a business of buying and selling that asset, which we say is simply not present here. And I accept that an isolate, if the respondents had entered into the transaction having already obtained the morecellement permit, for example, or had already taken steps to convert it into a morecellement, then that would be indicative of it being trading stock.
Can I just test that? Suppose that a wine merchant whose business consisted of buying and selling Scottish single malt whisky buys it as soon as he can from the distillery, but knows that it will sell much better after it's been matured 10 years, and so keeps it for 10 years before selling, and that was always the plan. Would that mean that the whisky wasn't trading stock when he bought it?
No, but there would be a frequency, my lord, in the buying and selling.
Well, you just suppose it's no. We all agree you can have a trade, a single purchase trade.
I would say, my lord,
I agree it's not typical, but that's not an issue on this appeal. You can a one-off is not the point.
It is not an issue in this appeal, but in the case of a wine merchant, yes, we agree that it could buy a single bottle of, well, not a single bottle, it could buy wine with the intention of letting it mature, but then it would be buying, there would be a regularity in the frequency. I don't think one could argue that a wine merchant would be in the business of buying and selling wine if he buys a single bottle of wine.
No, I didn't mean a single bottle, I meant a consignment.
In this case, there's a single, and
Well,
there is
you're
an
kind of-
overlap with the
By calling
accident.
him a wine merchant, you're kind of answering your own question away. Suppose it's not a wine merchant, but just a person who buys the output of a particular distillery, knowing that it's not drinkable now, but in 10 years' time it will be. You say that even though he may buy it intending to sell it in the future, that's not a business. But it's very difficult to know why it's not a business if it's not a business because it's an isolated transaction. That's what I'm struggling.
Yes, there is we accept that there is an overlap to some extent, which is why it was never our primary point with the badges of trade, and we certainly do not seek to revisit the badges of trade. And this is why we rely on the single time factor in this case. There is a case before, and apologies, it is not in the bundle of authorities for the principal reason that we were not planning to use this alternative argument. There is a case of, before the board, a 2008 case of Lutchman and the Revenue Authority, where it was not disputed in that case that land purchased to do a morecellement was trading stock. In that case, the land conversion permit was obtained prior to the purchase, and the morecellement permit obtained within the same year, and then there was a compulsory acquisition by the government. So the case turned on whether the sale proceeds on compulsory acquisition was taxable or not. So it's a different sets of facts, but we say that the timing or the period for which trading land is held is suggestive of its business character, i.e. is it trading stock?
You're talking about, is one way of describing what you're referring to as buying an asset as an investment? Is that what it is essentially? You're buying it as an investment on the basis that if you keep it a while, then it may become more valuable.
Yes, I mean, obviously, the ARC has made a finding that it was bought with the intention of doing a morecellement in the future, and we cannot interfere with that finding, or we are not able to. But it doesn't necessarily mean, we say, that that asset has been purchased in the course of a business of buying and selling land. That is indicative of a land developer, although I agree that the 10.3c does not talk about dealing, which is what the New Zealand Act did. That is why in the bundle of authorities we refer to section 88C of the equivalent act in New Zealand. That had three limbs. It had land dealing, it had scheme made for the purpose of making a profit, and it had an asset sold for no other purpose than resale. And
An asset bought for no other purpose.
Apologies, my lady?
An asset bought for no other
For no other purpose other than for resale. And when the legislator in Mauritius enacted 10.3c, they did not import the three limbs, they only imported buying and selling of immovable property. And we say that there is a nuance to be drawn between purchasing the asset for no other reason than resale at a profit, which is the test that the ARC applied, and land being bought in the course of a business of buying and selling property. There has to be a nuance, we say. Otherwise,
And it's not anything to do with the fact that it's land.
No.
No. But so if you were right, would it then fall out of tax completely, given that there's no capital gains tax?
No, it wouldn't. We are not saying, under this alternative proposition, we're not saying that the whole proceeds is outside the scope of tax. Indeed, in this case, the respondent never contended they had no tax to pay. They always paid tax. What they said is that I entered into a profit-making scheme, and it is the profit from that scheme which should be taxable. And that only makes sense if 10.3a applies and not 10.3c. And this is why we are trying to argue that 10.3c does not apply here. It is not.
But why do you say 10.3a would apply? Because
it is there are three reasons. So because, first of all, it is a scheme. If we accept that it is not trading stock, the proposition of why we would get to the same result as de Mahoussem only applies or is only relevant if 10.3c doesn't apply. This is where we agree with the appellant's case, that first, the board must find that 10.3c is not applicable. We will not get into 10.3a unless we convince the board that 10.3c is not applicable. And I'm happy to submit on what would be the result if 10.3a applied. But
yes.
This is essentially our submission on why 10.3c is not applicable. We say that based on all the cases, and we have not found an absolute rule, we'll be very candid about that, we have not found an absolute rule as to what would constitute trading stock. But when we look at all the cases in the bundle of authorities, and all the other cases that we have looked at for the purposes of this appeal, the asset which constitutes trading stock is always sold within a very short space of time.
But the 10.3c doesn't actually use the words trading stock.
Yeah, it doesn't, but that
Trading stock is the tag that's given to immovable property which is acquired in the course of a business, the main purpose of which is the acquisition and sale of immovable property. That is then trading stock, if it falls within that
10.3.
phrase.
Well, you're just using that as a label. but
Exactly.
Yes, we're using it as a label. We accept it's not the word used.
Right.
It is used, I see, in the following provision.
Yes.
But which bit then of 10.3c do you say is not satisfied
In
here?
the course
In the
of
course of a business.
In the course of a business, yes.
Can we look at the provisions? Could you explain how 10.3d works, which does refer to trading stock? It's on page 396.
Yes, so 10.3d applies where there's a, effectively, and the way I read it is when there's a sort of reorganization and there's been a transfer of trading stock into a new entity. Funnily enough, the case that I just referred to, the case of Lutchman, carried on in litigation further down the line, and I believe in 2013, they transferred the land, which was this trading stock, into a societe, and the litigation was about how to value, how to tax that apport into the societe. So we do not say that there's a 10.3d applies to when the asset which forms part of the trading stock is transferred as part of a reorganization or otherwise, but it doesn't mean that 10.3c does not apply to trading stock. I believe the appellant accepts that it is trading stock and says so in its written.
Well, they may do, but 10.3c is triggered, as I read it, just looking at the ordinary meaning of the language,
Yes.
in relation to any movable property or interest in movable property which is acquired in the course of a business, the main purpose of which is the acquisition and sale of movable. Now, the finding of fact which you can't challenge is that there was a business set up which consisted of the acquisition and sale of immovable property before, or at least at the time when, this land was acquired. So why is the "in the course of" test not satisfied on the facts? Never mind whether it's trading stock or not. That may be a red herring.
Yes. The point I'm trying to make, Your Lordship, is that the finding of fact that we cannot interfere with is that there was an intention on acquisition to do a morecellement in the future. The question which the ARC was trying to answer is, was the land bought for no other purpose than resale at a profit? The Supreme Court displaced the finding that it was bought in the course of a business of buying and selling, albeit for different reasons that we are saying.
But you're ignoring the paragraph after the one that you showed us on page 42.
Yes?
Where the committee found that they were involved in a business,
Yes.
the purpose of which was the acquisition and sale of the property.
Yes, and
I don't understand why you link it back only to the question that they'd asked on page 40, was it bought for no other purpose than resale?
yes, and that is because, so they asked the question on page 40 at the top. They then answer the question in the penultimate paragraph, makes a finding of fact, and then says, therefore. So what we are saying is that the ARC asked a question, answers that the intention existed at the beginning to do a morecellement in the future, and therefore it is in the business of buying and selling. What we're saying is that there's a gap, there's a step missing in the reasoning of the ARC, because while it makes a finding as to the purpose of the taxpayer, it automatically concludes that it must be in the course of a business of buying and selling. There's a step that's missing that goes to the business character of the asset.
Well, isn't that what they discuss on page 41? They look at the fact that they were doing what was needed to make the land sellable. They look at the fact that one single transaction doesn't mean that there's no trade. They look at the intention, the size of the land, that it was a very big plot that would be difficult to sell without making a morecellement. All of those factors. And then they reject the explanation that was given about why the land was actually bought. No alternative explanation was put forward. The only explanation put forward was we bought it for our own private purposes, to build 4 houses, and they reject that.
Yes, so the ARC...
All of that is what leads ultimately to the therefore they were involved in a business, not just the finding that they had an intention from the very start.
We disagree, my lady, for the reason that we say that the ARC applied the so-called badges of trade in order to infer whether there was a profit-seeking intention. And that there are 2 parts to the test under 10.3c. 1, the profit-seeking intention, and 2, whether it was bought in the course of a business of buying and selling. The committee's finding of fact, which we cannot interfere with, is that the first test, the first limb was met. There was a profit-seeking intention at the beginning to resell the asset at a profit in the future, and then automatically concludes that therefore there is a business of buying and selling property. And what we're saying is that there is a step missing in between. It's a very, very thin, subtle one, but there is a step missing between.
I just wonder whether it proves too much, because section 10 itself, what subsection 3 is doing is defining what is meant by gross income derived from any business within 10.1b.
Yes.
Right, so it only comes within 10.1b at all if the income is derived from a business.
Yes.
So if you're right, then I think that would knock out A as well as C, wouldn't it? Because you're saying there was no business. Or is it so subtle that you say, yes, there was a business within the meaning of 10.1b, but the acquisition of this land was not in the course of that business?
That is what we're saying, my lady. The respondents have never contended there was no gross income derived from the business.
So what is the business?
The business is the scheme. The business is the development of the morecellement. That is the business. That is the scheme which the respondents embarked on, regardless of when the intention arose.
So you're saying they weren't in a business when they bought engaged in a business when they bought the property?
They did not buy the land in the course of a business of buying and selling.
Or in the course of a business at all?
In the course of a business at all.
But that flatly contradicts the rejection of their case that it was bought for personal use.
There's a bit of a red herring here, my lady, because the burden of proof on the respondents is not to show the existence of a specified purpose. The burden of proof on the respondents was to show that there was no purpose of doing a morecellement. So it's a negative burden. So even if in a situation where the respondents are not able to show a positive purpose, which the ARC rejected, they would have still satisfied that burden of proof if they had been able to show that on acquisition there was no purpose of doing a morecellement, which we cannot interfere with, so we will not go on that. But the burden of proof is a negative one. It is not a burden of proof to show what the positive purpose was.
But something's being bought in the course of a business. What is the opposite of that?
The opposite, there's two options. Options. Either it is bought as an investment, as a capital asset, or it was bought for the future use put to that asset by transforming it into, in this case, a morecellement. So what we're saying is that if we cannot interfere with the original intention, profit-seeking intention, it does not automatically follow that that land was trading stock at the time of acquisition, simply because the respondents were not involved in the business of buying and selling land, which is a finding that the Supreme Court displaces in its judgment, albeit for different reasons that we say.
Which you accept are wrong. The reason they've
Incomplete,
displaced
which
it.
we accept is incomplete in so much as the Supreme Court's reasoning only makes sense if there is no trading stock on acquisition. So if there's...
Well, the reason they gave was that there was a bare land qualifier.
Yes, that there
And you
was...
accept that's wrong.
We accept that's wrong.
They don't get into the question of trading.
They do not. This is what the
So
Supreme Court
they-
does not
So
address.
the reason they reversed it was an erroneous reason.
It was an erroneous reason, but it is still a finding that is displaced by the Supreme Court, which
On a
is
wrong basis.
on the wrong basis.
So you say because of the gap in time, the business really only came into being at the time they started to develop the land
Yes,
for
the
the purpose of and for the purpose of the morecellement. But didn't they draw up accounts? Don't we have the value of the purchase of the land in accounts that they
Once
draw?
the land had been sold. So the accounts show, I believe, 2005. I'm just going to see the accounts show at EB 57. So accounts, notes to the balance sheet, and we have 2004 and 2005. Much later, once the morecellement had already been sold, or was in the process of being sold. There's no evidence in the case stated that there were any accounts prepared at any point prior to.
Wasn't one of the objectives of the Société to buy land?
The Société was set up by the four respondents, now the heirs of one of the respondents, to purchase land. Yes, to purchase land, and obviously their stated intention was to build their houses.
Does your argument turn on what intention they had at the time that they bought it, as to how long they were going to wait, or does it turn on how long they actually waited?
How long they actually waited, how long the asset was held.
So suppose they'd intended to develop it as soon as possible, but reasons had delayed them, out of their control, delayed them doing so. You say that would be enough to take it out of the category of establishing a business for the purpose of buying and selling land.
This is, we would say that this is so fact-specific that if they were delayed, but they were in the course of a business of buying and selling property and they made another project, then of course they would be in the course of buying and selling.
No, we're assuming for all of this that it's the only venture they're engaged in.
We would say that, to answer your point, my lord, we would say that in this circumstance, even if they were delayed, say, for example, because the licenses were taking a long time, there would already be, we say, an indication at the time of acquisition or shortly thereafter that there are plans in place that it is part of a business. In this case, the earliest we have of any indication whatsoever that there was a scheme being planned is 1994, when a survey was made. So even if, the point we're trying to...
Isn't that part of what the court rejected, what the ARC rejected? They said that there was the intention. So even before they took that first step, that they always intended there to be the morecellement. But so what are you saying? That in order for there to be a business, in addition to their intention when they acquired it in 1988, whatever. There has to be some kind of other activity that forming the société is not enough of itself.
And buying the land.
Buying the land isn't enough of itself. There has to be some kind of other step or steps of a business type for that then to be the course of the business to start running.
Yeah, the key point, the key factor we say that this is the decisive factor or characteristics of a trading stock is the duration for which the asset is held.
I think you're saying it's the duration for which it's held in fact, rather than the intended duration at the time of its acquisition.
In fact.
I think that's what you're saying.
Yes, that is what I'm saying.
Because what troubles me about that is that whether or not subparagraph C is triggered isn't about how long it takes before the land is sold. It's about in the context of what business it was acquired.
Yes.
So that, let's suppose they don't know how long they're going to hold it for when they acquire it. Nonetheless, they're acquiring it in the course of a business, which is the acquisition and eventual sale of the land. It doesn't look as if the statutory test for the applicability of subparagraph C has anything to do with how long in fact it was held. I mean, let's suppose they had the most terrible battle royal over planning, so that it took 4 times as long to get round to selling it as they expected it to. On the face of it, wouldn't make any difference to whether subparagraph C applies. It's not the subsequent history that matters, it's quo animo it was bought.
Because it's the purpose. The relevant question is the purpose. And that is the purpose at the time of the transaction, isn't it? Because you accept that there was a business, one way or another. The question is whether the purpose of the business was buying and selling land. And so mustn't you have to look at what their intention was at the time of the business was established?
Yes, and that is why it was our primary proposition. And that secondary proposition is that there are 2 limbs to the test, as contended by the appellant itself, that there is the purpose and there's the business character. And the second point is a more subtle one because there is an overlap, obviously, with the facts. There is an overlap, obviously, with the badges of trade. And we say that a land cannot be properly characterized as a trading stock if it is left idle for 11 years. And we do accept that it is entirely possible that the application process could have taken a long time, etc., etc. But in this case, the application process started 8 years later. So there is...
So you're saying there was a business, are you, which was where they intended to develop and sell the land, but the land was not acquired in the course of that business. Is that your argument?
That is our argument, and our argument is therefore, and we can only get into 10.3a if we convince the board that 10.3c is not applicable, and our submissions under 10.3a, once we get there, is that the timing of the intention doesn't matter. So
just to go back to the point that my Lord Legate was making, so you do accept that at the time they acquired the land, they were operating a business?
we do accept that because we cannot interfere with the finding of fact,
yes,
we do accept that if the ALC was right, that on acquisition of the land, there was a profit-seeking intention. What we do say, however, is that it does not automatically follow that the land was bought in the course of a business of buying and selling.
That's not quite my question.
Yes.
The question is, do you accept, because you have to or because on the facts it's true, do you accept that at the time they set up the société and the company put the land in and then withdrew and they all joined, that there was a business going on at that point?
We accept that there if we interpret business to mean an income-earning activity with a view to profit, we accept that there was a business, but we say that the land was not bought in the course of a business of buying and
You're saying whether the land was bought in the course of a business depends on what happens later, after it was acquired.
No, we say that if the land can properly be characterized as a trading stock, depends on how long it was actually held for.
Yes, and therefore you can't decide whether it was acquired in the course of the business until years afterwards.
Sort of wait and see provision.
Normally, in the ordinary course of things, if someone is in the business of buying and selling land, the question is, the answer is kind of self-evident because you would have a history.
But you've accepted a single transaction
Yes.
can be...
Yes, we've accepted
Well,
that.
so there's never going to be that history. So is my lord right? You've got to wait for 10 years to determine whether the land was acquired in the course of that business.
Not necessarily, because if we look at, and that is when we say that the duration for which the land is held, we also refer to the what else was going on at the time, and that is why we say that it is during the course of a business. What else was going on at the time? Nothing. There was no surveys, no application, no indicia whatsoever that it was in the course of that business. If land is trading stock, even if it is held for a long time, at the very least on acquisition, you don't have to wait and see. On acquisition, it is quite clear that you have, that it is trading stock because there's applications for permits being made.
Well, you say so, but it's the common business of many developers to hold land in a land bank. They acquire the land, reckoning, using their business expertise, that in due course it will become developable, but it isn't yet. So it just sits there. They don't do anything with it. It just sits there as part of their land bank. But I think you're saying it only becomes part of their trading stock when they start to sort of do things in relation to it rather than merely banking it.
There is slight nuance to that in so much as in the example you give, and that is the difficulty we have with interpreting that section. We agree that it is fraught with difficulty, is that in the example that you've given, the land developer wouldn't have one single project. And we accept that an isolated transaction cannot constitute.
I agree.
But there is recurrence and there's
example.
frequency, which is not present here. So what we are saying is that if an isolated transaction has been entered into, and we accept that in principle an isolated transaction can constitute a trade, what decisive factor is there that would make the business character of this asset trading stock? And we say it is the length for which it is held.
But this is hardly going to be conducive to certainty in the law and knowing what the actual position is. I mean, what you're suggesting is that even though there's an intention of buying and selling, it's not automatically in the course of a business. Now, I would suggest to you that it is automatically in the course of a business, because any other rule is going to be conducive of massive uncertainty. And what you're positing is, oh, well, if you look 5 years on and nothing appears to have been done, well, we can retrospectively say it wasn't acquired in the course of a business. But you can't have a legal rule based on that sort of uncertainty, particularly in the tax sphere, can you? It wouldn't be a sensible rule, would it?
The question to be answered here, the question only arises when there's a sale of the asset. So then the rule has to be interpreted in seeking, first of all, to find that intention, which we're not interfering with. And we see in the reasoning of the ERC that intention was inferred by looking at events that happened years later.
Well, you say you look backwards, but surely a taxpayer is entitled to organise his or her affairs in the best way possible,
Yes.
and to consider what the tax consequences of the transaction will be.
Yes.
And if the taxpayer won't know whether land is going to be treated as a 10.3c gross income or a 10.3A gross income. That's, as my lord said, not conducive to certainty.
The taxpayer knows. What we're trying to convince the board is that how do you determine whether it's trading stock? The taxpayer knows whether it's in the business of buying and selling, and what we're saying that here, it is not trading stock, and the decisive factor here is the duration for which the asset has been.
So you say there has to be some other thing that then triggers the commencement of the scheme. Is that
Yes.
right?
Yes, which is here in this case, it's the transformation. I would have a different view
Yes. But
if the land had been sold as bare land, which is why we have always said that the Supreme Court's reasoning is incomplete and not wrong. If the asset was bought for no other purpose than resale at a profit, so and it was bought in 1988 and sold in 2003, and the committee made a finding of fact that the intention was to sell for no other purpose than resale at a profit, then we accept that land may well be taxable, or would have been taxable, because it was sold as bare land. Here, we are saying that it is a scheme, but we accept that it can only fall within 10.3a if it does not fall within 10.3c. And the key distinguishing factor here, we say, is that the land is not trading stock. It is not in line with economic reality for a land developer to enter into a single transaction and hold on to idle land for 11 years, and that land is trading stock, and transform it so significantly that it bears no relation whatsoever when he sells it to when he first bought it, which was wasteland.
what we're debating here is the value to be given to one of the deductibilities, one of the deductible items in calculating the income. Now, if you just sold it as bare land, then really the only deductible item from the the proceeds of sale would be the cost of the land.
Yes.
But if you develop it, then presumably you would also, or I don't know, whether you would also seek to deduct from the proceeds of sale all the costs that you incurred in addition to the actual cost of the land. But we're just, so you would have, your profit would be lower because you've spent all that money on developing it, and that's a deductible expense, let's assume, right? So you're still only talking about what is the value of the land as a deductible expense from the proceeds of sale to arrive at the profit.
Yes.
But you say that that value is not the cost of the land, it's the value of the land at some point when you start incurring those other expenses which you're going to want to deduct from the proceeds of sale. Is that what you're saying?
Yes, immediately prior to development. And,
Right.
and we agree with the appellant that that computation ultimately turns on whether it falls under 10.3a or 10.3c.
Right. So suppose I'm in business as a jewellery maker and I buy gold. And I make the jewellery from the gold and I sell it. And during the time that I'm making the gold and selling it, making the jewellery and selling it, the price of gold in the market goes up because of some crisis in the world, whatever.
Yes.
So then, do you say that I'm entitled to deduct from the profits of my jewellery business the value of the gold at the point I started making it into jewellery, even if that's substantially more than what I actually paid when I bought the gold?
No, my lady, because in the case of a jewellery maker, again, this is the difficulty with the isolated transaction point, because there would be a regularity and a frequency to that. You know, that argument would only possibly can be raised if someone bought a single piece of gold.
The trouble with saying, oh, well, that all is because it's a regular repetition transaction, that all goes to whether it's a bought for the purposes of business. And you've got a finding of fact that this was bought for the purposes of business. But you're trying to say yes, but it wasn't bought in the course of that business. Even though the business was the acquisition and sale of land, and it was acquisition of land.
And that is why we say that the distinction is extremely subtle, because
Yes, it is a very subtle one.
yes,
Yes.
we have, that is why it was not our primary proposition, my lord, because the test, and that is why we've compared it with the New Zealand Act. The test isn't, has the land been sold when it was acquired for no other purpose other than resale as a profit? And we say that if the legislator had intended to say that, it would have clearly imported the New Zealand.
Well, do you want to just show us the New Zealand wording
Yes,
so
of
we
course,
see
my
that,
yeah,
the point you want to make?
So, EB 405. So it's 88C. 88C says all profits or gains derived from sale or other disposition of any real or personal property or any interest therein. And there's 3 limbs. First one is, if the business of the taxpayer comprises dealing in such property, we accept that 10.3c doesn't talk about dealing. Second limb is, if the property was acquired for the purpose of selling or otherwise disposing of it, this is a profit-seeking purpose. And 3, any profit or gain derived from carrying on of any undertaking or scheme entered into or devised for the purpose of making a profit. So there's 3 limbs there, and then somehow when it was translated into the Income Tax Act 74, from which the New Zealand Act was inspired from, we sort of lose that second limb, and we are only left with business of buying and selling. We accept that the 10.3c doesn't say dealing, we accept that. But we say that there must be some difference, albeit very subtle, between buying property for no other purpose than resale at a profit and buying an asset in the course of a business and buying and selling. And we say that the only distinguishing factor is when you buy an asset and hold it for very short duration, then that is a trading stock.
But it isn't the reference to dealing there in 88C, in fact then encompassed in 10.1b that it has to be a business, because the header to 88 doesn't mention a business.
Yes, we accept that. And when the Income Tax Act 1974 was enacted, those subsections, so the 10.3, the equivalent of 10.3c and 10.3a, were contained outside the definition of gross income from a business. It was in addition to. And when the 1995 Act was enacted, 10.3a was subsumed under gross income from a business. But we do not know why that is. Perhaps my learned friend for the appellant there could shed light on it in due course, but yeah. So in 1974, it was very similar to the way the New Zealand Act read.
Well, you're not under, we've broken clean off, we've gone off piste so far as time is concerned, but we might have done that point quite thoroughly, I think.
Yes, and our concluding remarks on that would be that if we accept that 10.3c is not applicable, then we will make very short submissions on why on 10.3a it is the de Marusan principle that is applicable regardless of the timing of the intention. And we say that because of a possible point that the appellant would have raised is that the computation depends on when the intention arose, and we say it does not depend on when the intention arose, provided 10.3c is not applicable.
So you're saying that if you get within 10.3a,
Yes.
then for some reason, which you say is the de Morrison case,
Yes.
the value that is deducted from the proceeds of sale in respect of the cost of the land is the value at the start of the scheme, whenever that is, rather than the acquisition.
Exactly, yes.
And that's because there was some change in the nature of what...
Yes, 3 reasons, my lady. One, it's because the business then, if it's not under 10.3c, the business then is the scheme. So as their lordships put it in the de Mauritius case, the putting into place of a morecellement requires a substantial transformation of the land. It requires significant infrastructure and developmental works. There's roads, sewage, water system, utilities, all of this has to be put in place in order to put a morecellement in place. So it requires, and this is where we are aligned with the reasoning of the Supreme Court, a morecellement is a scheme, so it requires transformation of the land. The land has to be substantially transformed, and that is the business. The business is the scheme.
But if you can deduct all those costs also from the proceeds of sale, I don't see why the element of the land, which is deductible, shouldn't still be the cost. Why do you suddenly bump up the value of the land?
Because
because you've incurred all those other deductible costs.
So you do incur the deductible costs, but the reasoning of their lordships in the de Mauritius case is to adopt what they call an intermediate view and say that it is not reasonable, it defies economic logic to read benefit from the scheme as the whole proceeds minus expenses. It is the profit arising from the scheme that constitutes the gross income, and therefore the developmental value of the land prior to the scheme being implemented is not attributable to the scheme.
And the scheme doesn't start when the land is bought.
No.
The scheme doesn't
Indeed.
start when the land is
A is really
It's the capital
complicated situation
gain.
where the landowner has the land, but having got it, he might even have inherited it, but without any intention when he acquired it of developing it, and then enters into a scheme. Then you draw the valuation line
This is where you draw
immediately
the
prior to the scheme to avoid him having to pay gains,
Yeah.
a form of concealed gains tax on merely holding the land as an inheritance for 50 years before it got schemed or sold.
Well, there wouldn't, on any view, be a scheme at the time of acquisition.
No.
But here,
Yes.
at the time of acquisition, the intention is to carry out the morecellement. So it's not obvious to me why the scheme doesn't begin then.
because the scheme is, and as I mentioned, the scheme we say is the transformation of the land. The asset that is sold is completely different to the asset.
But it's not completely different. It's land on which people can build things. Why do you say it's completely different?
It was purchased as effectively wasteland, and when it is sold, it is a morecellement with roads, with infrastructure works. There's a whole process that had to be followed. They could not simply divide it. A morecellement is not simply subdividing land. It is a substantial scheme entered into, and that is what their lordships found in de Mauritius. They listed all the drainage works, etc., in order to enter into a scheme. Effectively 2 reasons why we say that it is the de Mauritius principle that is applicable if it falls under 10.3a. 1, it is the profit from the scheme that is subject to tax, and the scheme is the morecellement. And 2, 10.3a says very clearly, irrespective of the time in which the scheme is devised or entered into. So the timing of the intention does not matter if you're a scheme within 10a, assuming you're not under 10.3c. So it's irrespective of whether the intention arose in 88 or 96 or 99. It is the profit attributable to that scheme that is subject to tax, and that is why we say that the Mauritius principle is the correct method of calculating the taxable profit, provided we do not fall indeed within 10.3c.
You said there was a third point.
Well, I covered the third point. The first point was to
Profit from
show
the
to your
scheme.
lordship why it is a scheme. Exactly. I believe I've covered everything, your lordships, unless I
Thank you
can
very
assist
much.
you any further.
No, I think we should hear me.
Yes, Mr. Maker.
I suspect I can be quite short in replying here.
Well, in this court, brevity is always a virtue.
The starting point is the wording of 10.3c, immovable property, where the property was acquired in the course of a business, the main purpose of which is the acquisition and sale of immovable property. And my learned friend rests her point of law, which is an entirely new point. This has not been raised before the argument of the course of in the course of the business. I'm afraid I have difficulty seeing how the reference to a land dealing company in the very brief comments of counsel in the Supreme Court gets you from there to a discussion of the meaning of the course of business. I didn't see anything in the rest of the submissions or the skeleton that turns on that point, but leave that aside as a completely new point. If it does turn on the course of the business, we then need to turn to the finding of fact of the ARC. And the ARC, this is page 43, you've seen it many times. In these circumstances, the committee has no hesitation in holding that the facts of the case show that the applicants from the very beginning bought the land through the Société du Vieux Moulin with the intention of having a morecellement done after a few years in view to make a considerable profit. Well, they conclude that there was a business of buying and selling land. If from the very beginning you buy the land with the intention of having the morecellement, I find it extremely hard to see how that is not in the course of that business. Learned friend said it's a very subtle point. I'm afraid the subtlety is lost completely on me there. But what is not lost are several of the points that your lordships and your ladyship made in questioning the learned friend, and in particular Lord Barrow's and Lady Simler's comments about certainty. There would be absolutely no certainty if that were the interpretation of the legislation. In fact, there would be a very great danger for Mauritius, and I suspect that if your lordships were to follow the submissions of my learned friend, it would need correcting legislation, because one could imagine that any property developer who acquired land would say, well, we bought the land, we knew that land prices go up and we intend to make up the game. We wait until we're ready to start a development. And at that point in time, we take the value, and it's only the increase from that time onwards that is taxable.
That, I think, was my land bank point, but I think Ms. Hague sought to answer it on the basis that, in that case, you've got the requisite repetition for it to be trading stock.
But if you had a land company that, not unusual, acquired a particular parcel of land in an individual company, that they would simply acquire in a separate company and say, well, we only have carried out one transaction. I'm not certain that I see why a single transaction, once you accept that a single transaction is a business, I don't...
Why should we get a different tax
Why should we get a
rate?
different answer? And in particular, why aren't you encouraging land developers in Mauritius to acquire through separate companies? Land developers in Mauritius are not slow to take the decision of the Supreme Court here and say, oh, well, we only have to wait until the moment that we've got our morecellement permit, and it's only the profit from then onwards. There's been in the background here the discussion of capital gains and non-taxable capital gains. The whole point of 3C is that it brings within the charge to income tax gains that might otherwise have been capital. It's what's said in de Marasem at the beginning. It brings into charge to income tax gains that might otherwise be capital, but because they are in the course of a business, the main purpose of which is the acquisition and sale of immovable property, they are taxable. The fact that if somebody inherited land and then sold it, there is no capital gains tax on land in Mauritius. The legislature has chosen that, as they've done in New Zealand, to bring in these particular profits to income tax. And I think it's as simple as that in my response. That in the light of the findings, I really cannot see how one can interpret in the course of to say that this was not acquired in the course of the business, and it would be very dangerous to come to an alternative conclusion. And
So you say that you say that the finding of intention at the time that they acquired the land to have a morecellement is of itself enough for the acquisition to be in the course of a business for the purposes of 10.3c.
in this case, yes, that from the very beginning, the bought of land was bought with that intent.
But are there any other findings in the ARC decision that you would point to in addition to that finding of original intention that indicate that it was a business? Because I think the point made against you is that actually the point of law is that the ARC, yes, they made a finding that it was in the course of a business, but they did that solely on the basis of the intention at the time of the original acquisition. That's not actually enough. It doesn't have to be lots of different transactions, but there has to be something else that indicates that it's in the course of a business other than the pure intention at the time. Now, we've looked at the fact that I don't know whether the fact that they bought this through a société or whether there's anything in the ARC decision that points to them looking at other things as well as the intention in order to conclude that it fell within 1C.
Well, in a sense, the whole of their decision where they reject the explanation from the respondents leads to that particular conclusion that they reach, because the starting point is that the Mauritius Revenue Authority sought to charge tax under paragraph C, and that's mentioned at the beginning of the case stated. The onus of proof is then on the taxpayer to explain why it's not within C. The only explanation that is given is, oh, we acquired it for our personal use in order to have our personal homes there. That's rejected by the ARC. So there is no alternative explanation as to the purpose for buying the land. Then they do, of course, apply some of the badges of trade. And they look, for example, and I take issue with some of the comments in my learned friend's written case, that they haven't correctly applied the badges of trade. That's not an issue now. But one of the key badges of trade is the subject matter. The subject matter here was a large parcel of land that was eventually divided into 93 separate building plots. And that's clearly a factor that leads it's rather your land bank point. This is a large plot of land that was bought in a société. And I know my ladyship is very interested in corporate law, and I no doubt the articles of association of the société would have been of great interest, that the société did have as a second object the acquisition and disposal of land, and that's one of the factors. So in a sense, it's the totality of the decision which leads the ARC to reject the alternative explanation and leads it back to saying, well, you acquired land right at the beginning of the business. You acquired it with the intention of selling it. That must be in the course of the business, and I don't see that you come to any alternative.
There was no alternative argument put forward to the ARC. They didn't say we were just going to use it for our personal use, but even if you're against us on that, still our intention at that time is not enough because it's still not in the course.
Nothing there whatsoever. And again, I take it to my learned friend who says there was undisputed evidence. The evidence of Mr. Gallia, the only explanation he gave was, we wanted to build our own houses on this Mauritius, very large plots of land. I wanted to be near my children's school in La Bourdonnais. They don't accept that. There's no alternative explanation put forward. And in fact, the documentation, it's very thin documentation here. Again, I stress, in Mauritius, it's for the taxpayer to displace the assessment and to show that there was an alternative intention.
In context, it was a binary choice for the committee, as I understand it.
Yes.
There was no middle ground like using it for shooting Mauritian types of pheasant or golf or anything like that.
No.
Either they wanted it to build their houses on it, or they were going to want it because they wanted to resell it at a profit.
That's right. And once it was not accepted, their evidence, then the assessment under paragraph C remains because they've not given an alternative explanation. I'm not certain, I'm very happy to answer any questions, but I'm not certain they can assist you any further on that.
Oh, well, thank you very much.
Straightforward.
Any reply? The great advantage of your opponent saying anything, however brief, is that you get a second bite of the cherry.
Thank you. Two things, my lord. My learned friend referred to the objects of the société, and of course the ARC, rightly in our view, do not rely on that as a reason for their finding, and this is in line.
Do we have those in the bundle?
Yes, we do. It is at page. The French version is at starts at page 59 of the EB, and then there's an English translation.
Well, they probably have well in mind that any well-drawn set of articles of association of the société will probably include that somewhere.
Yes, exactly.
Without
That was
that was its main or substantial business.
That was the point made by by Mr. Gallia in his examination in chief, that they are deliberately wide, and the ARC does not rely on that in its finding. And
well, you didn't rely on it. You didn't rely on it to say. I mean, I don't have a sense of why they did this through an associé rather than just buying the land jointly.
Yes, there's a case of d'Anjou in the bundle of authorities that give context, the Mauritian context, to why people use a société. I'm happy to take your leadership to that, but in that case, it is made very clear by their lordships that there's nothing sinister about using a société in Mauritius. People use it for succession planning purposes and to hold land. And indeed, the ARC does not rely on the objects, the statute.
And quite apart from anything else, if you're going to sell it, it probably makes the conveyancing an awful lot easier using a société than just doing it as joint owners.
Indeed, and also the...
it also avoids registration duty.
That was also the stated reason of Mr. Gallia, that it was to avoid registration duty at the time.
Yes, well, I think you dealt with that point.
Yes, there was one other point that I wanted to raise, is just to answer to my learned friend's proposition that it would be dangerous if we were to adopt that any land developer could simply wait for the land to accrue in value. And again, we go back to our point about the economic reality. Would a land developer effectively put on hold his business just for the sake of getting a better tax treatment on sale of his land, assuming there's an isolated transaction? One has to bear in mind that in Mauritius, there is land transfer tax and registration duty on the market value of the land on a gross basis. So if a land developer were to do that and wait 10 years they would have to pay land transfer tax at the market value when they sell the morecellement. So again, we submit that it would defy economic reality for a land developer to use that as a potential arbitrage option. In addition, it would be open to the Revenue Authority to raise an assessment under Section 90 of the Income Tax Act, which is the general anti-avoidance rule, if the only reason why the land developer did that was to secure a tax advantage. To sit on land for years just to get the Demarcem computation. That was all.
Can I ask you,
Yes.
is the argument you developed this morning to be found anywhere in your written case? And if so, could you kindly show me where?
We left a very small door open, Your Lordship, and we do agree that that was never our main proposition.
There's a bit of it the size of a grain of sand, but you're going to show us where that is.
It's a footnote. So it is at page 367, 367 of the Bundle of Authorities.
367.
367.
7. Right.
Yes, so on paragraph 55, where we concede that 10.3c does not contain any bare land qualifier, we say it is also not contested that it is possible in theory that land acquired with the intention of doing morecellement may constitute a trading stock, provided it is acquired in the course of a business, the main purpose of which is to buy and sell property. And then in 56, when we reply to the appellant's contention that 10.3c would be largely redundant if we adopt the Supreme Court reasoning, we say this paragraph applies to a land dealing business. And then the footnote is reference to the Demarcem case that talks about a land dealing business. That is the very small door.
It can hardly be said, it'd be fair to say, that you've made a positive submission that this is not a land dealing business in your written case.
I
You merely identified a theoretical possibility.
We accept that. We did not, to be perfectly candid, Your Lordship, we did not expect an objection to be raised in the light of the concessions, as it were, that we have made in the written case.
Well, we've heard it on the merits, for better or worse. No, well, we're most grateful to both counsel. Mainly for your oral submissions in the events that have turned out, but also to those who've no doubt assisted in presenting the case. And the board will take time to consider its judgment, which will include the reasons for not allowing you to pursue